General partnership. A general partnership, GP, is formed when two or more persons associate to carry on a business for profit as co-owners. There are no formalities required to form a GP. The subjective intent of the parties to form a GP is also irrelevant. You don't even need a written or formal agreement. General partners are each personally and jointly and severally liable for the debts of a GP, whether arising in tort or contract. There is no limited liability for the partners of a GP. A presumption arises that there is a GP and that the persons are partners when such persons share profits, unless those profits are shared due to being rent or repayment of a debt rather than true profit sharing. Other factors that may evidence a partnership, but these factors do not create a presumption, include the sharing of gross revenues, the sharing of losses, whether the persons call themselves partners and call their business a partnership, and the extent of the business activities. Greater extent of business activities suggests a partnership. Partners have no right to compensation, meaning wages/salary, absent an agreement to the contrary. Partners have equal rights to manage the business of the partnership and control its affairs. Corporation. A corporation is formed when articles of association are filed with the Secretary of State. The articles need to have the name of the corporation, the names and addresses of the incorporators and registered agent, the authorized stock of the company and associated rights, and the purpose of the corporation, which can be any lawful purpose. A de jure corporation comes into existence only when the Secretary accepts the articles. There can also be a de facto corporation if the state has an incorporation statute. The persons make a good faith colorable attempt to comply with the formalities for forming a corporation, but fail to do so, and such persons assert the privileges of a corporation. Limited partnership. In a limited partnership, there are general partners and limited partners. The limited partners have limited liability, meaning they are only liable to make their capital contributions. A limited partnership is formed when a certificate of limited partnership is filed with the state, executed, signed by the general partners and stating the name of the limited partnership, which must have LP or limited partnership in the name. An LP comes into existence when that public document is filed, or on the deferred date for existence to take place, if any. Limited liability partnership. A limited liability partnership requires filing of a certificate of qualification executed by at least two partners, and must have LLP or limited liability partnership in the name. An LLP comes into existence when that public document is filed, or on the deferred date for existence to take place, if any. All partners in the LLP have limited liability. Here, there was no filing with the state, so the firm is not a LLP or LP. Limited liability company. An LLC is a hybrid organization. Its owners, members, have limited liability like a corporation. However, LLCs get the pass-through tax treatment that partnerships get. On the other hand, corporations are subject to double taxation, taxed once at the corporation level, and then again when distributions are made to shareholders. To form a limited liability company, a certificate of formation must be filed with the state. Here, there was no filing with the state, so the firm is not an LLC. The owners of an LLC are called members, and the owners of a corporation are called shareholders. Employee. An employee is someone who is hired by an employer to provide services to the employer regarding the employer's business. An employee is an agent of the employer, who is the principal. Evidence of an employee-employer relationship can be found when the employee is paid a fixed salary or wages, and where the employer has authority for managing the details and method of how the employee performs her job. Partnership and contracts. A partnership is bound by the contracts entered into by its partners and employees, both of whom are considered agents, where such agents had actual authority, apparent authority, or where the partnership ratifies the agreement. Actual authority. Actual authority can be express or implied. Express actual authority is where the partnership expressly by words or writing provides authority. Implied actual authority exists where, based on the manifestations, words or conduct of the partnership, the agent reasonably believes she possesses authority. Apparent authority. Apparent authority exists where, based on the manifestations of the partnership, third parties reasonably believe the agent has authority to bind the partnership. The partnership statute says that apparent authority exists where the partner is acting within the scope of the partnership business or business of a kind conducted by the partnership, unless the partner lacked actual authority and the person knew or received notification of such. Ratification. Ratification is where the partnership agrees to the contract after it has been entered into, either formally and expressly through a formal decision, or impliedly by accepting the benefits of the contract. General partnership. A general partnership is an association between two or more people to carry on as co-owners a business for profit. There are no formalities required to form a partnership. There is no writing requirement or filing requirement with the Secretary of State. The subjective intent of the parties is immaterial. All that is required is that they intend to carry on as co-owners a business for profit. In other words, a partnership is formed simply by meeting the definition of a partnership. Libel. A prima facie case for libel requires a defamatory statement of or concerning the plaintiff, publication, and damages. In addition, when the defamatory statement concerns a public figure, such as a Major League Baseball player, the plaintiff must prove falsity and fault. For the fault requirement, a public figure must prove actual malice. Actual malice exists when the defendant knew that statement was false, or recklessly disregarded the truth or falsity of the statement. Defamatory statement of or concerning the plaintiff. A statement is defamatory if it adversely reflects on the plaintiff's reputation. Publication. For publication, the defamatory statement must be made to a third person who understands it. Damages. Sam suffered general and special damages. Partnership, tort liability. An employer/partnership will be vicariously liable for torts committed by agents/employees/partners that are within the scope of employment/partnership. General partnerships are jointly and severally liable for all partnership obligations. However, the creditor must first exhaust partnership resources before seeking payment for partners individually. Partnership, contract liability. A partnership will be liable for contracts entered into on its behalf by agents who have actual or apparent authority or contracts that have been ratified by the partnership. Actual implied authority. There is actual implied authority when the agent reasonably believes he has authority based on the manifestations of the principle. Actual express authority. There is actual express authority when such authority is granted in the four corners of the partnership agreement or expressly granted by a requisite vote. Ratification. Ratification occurs where an agent purports to act on behalf of the principal when in fact he does not have actual or apparent authority, and the principal subsequently ratifies the action with full knowledge of its terms.